Another officer on the stand in the Shawn Grate case out of Ohio. We are listening to some discussion about getting an interview transcript onto the record to help break some of this case down. Brian Wagner, one of our guests, is back here. He's an attorney in New York City. Brian, we were just talking about just the heinous nature of the accusations in this case. And it was personified by the victim who was able to escape this disaster being on the stand earlier today. Just horrific details. She encountered, she recounted rather, just fact after fact after fact pertaining to this rape. It was horrific to listen to, but it had to be put on the record.
Good afternoon, Aaron. Thank you for having me. Absolutely. As the defense attorney in this case, what you're trying to do is play small ball, right? That's a sports analogy where you're not going for the home run. You're not trying to prove that she's a liar, but just get little wins, little win, little win, little inconsistencies here and there, so that on summation, you could tell a much more compelling story. But it's an uphill battle for sure.
And it seems that the cross-examination of that witness was about things that the defendant did that weren't heinous, because the relationship started out normally. You know, he went here with you, he did Bible study with you, and they harped on those points. Now, I thought, when I heard that it was to try to play into this argument that we're expecting that they did some brain imaging and they're going to try to, you know, complain that there's something wrong with what's going on inside his head. Let's hold that thought, though. Let's go back to court. We are listening to an interrogation recording with the defendant that was entered into evidence by the police officer who's on the stand, Officer Curtis Dorsey of the Ashland Police Department. It's a little bit hard to hear. This probably, Brian, sounds like a squad car recording. That's my guess. Usually interrogation rooms are a little bit more clear than this. It's been tough to pick up bits and pieces of it, but I've heard a few snips here. Things like, I don't even know her name, and it's been a long time, and there's some discussion about windows and whatnot. So even though it's a little bit hard to hear from our perspective, I latched onto that one line. I don't even know her name. I don't know who he was referring to, but is it possible he's referring to a victim here?
Absolutely. What you tend to do as a prosecutor with interrogations, you explain to the jury that they're going to admit what they can't deny and deny what they can't admit. So I don't even know her name. If that's really crucial, then the defendant or the client is not going to admit to that. But as a prosecutor, you've already told the jury that that's what you would expect. The other issue, as a defense attorney, what you're really trying to say is, before you can ever credit this testimony in terms of the interrogation, before you're even allowed to consider it, it has to be voluntary. And so on cross-examination, that's what you're really going to concentrate on cross-examination.
So, look, statements can be given, Miranda rights can be waived, and we heard at the beginning of this, you know, you understand rights and whatnot, and he keeps going, meaning the defendant keeps going. So, look, he waived his rights, so this comes in, as long as it's a knowing and intelligent waiver.
Those are two different issues. It's always going to come into evidence, but the weight, how much the jury is going to credit it, is something else. And so what you do with summations is you say to the jury, ladies and gentlemen, the judge is going to give you an instruction on the law. And part of that instruction is going to say that you can't even consider this statement unless you find it was voluntary, meaning he knowingly waived those rights, his Miranda rights. And yes, the judges let it in. But I submit to you, ladies and gentlemen, it's coerced, that he wasn't actually acting of his own volition, but that the detectives forced him to do this. And for that reason, ignore it completely. And then, if you get past that and you're going to consider it, it actually means nothing, because he's denying what actually happened, and the police are just forcing it upon you to say that this connects the dots.
Well, but still, I mean, our jury's going to actually go ahead and make that leap, because this is still language that's coming out of the mouth of the defendant himself.
Yes, they will. But with a big caveat, you know, what you don't like as a prosecutor and you like as a defense counsel is a corroboration and confession case where the only real evidence is the defendant's own statement. That's a great case for the defense because, frankly, statements are coerced out of defendants quite often, or at least juries believe that. But in this type of case where there's other corroboration, whether it's eyewitness testimony that we heard today or forensic evidence, then that statement it just becomes another piece of the puzzle, and it's hard to really remove it from the jury's mind. So in this case, the statement's going to most likely, in my opinion, carry the day. But if it was just by itself, then you could certainly consider that.
I think what's going to carry the day in this case is the testimony of the victim who was on the stand earlier. She's looking at this guy. Okay, we couldn't see her face. She's victim. Okay, so no cameras on her, but we did see the defendant. And apparently, you know, she's looking at him and saying, this is the guy who did all of these horrible, horrible, horrible things to me. She was cool on the stand. She admitted that when she first got to know him, nothing rang the red bell in her head that there was an alarm on this guy. But then he snapped, and then it turned into this abusive situation. You know, she's tied up. She's being attacked. She's being sexually attacked. And that's what she described. You've got that. You've got forensic evidence. You've got officer testimony. You've got dead bodies in the house, sealed up. You've got fly larvae. You've got all of this stuff. So you have a survivor on the stand. You've got forensics. You've got bodies. You've got now this recording that's hard to hear. But look, oftentimes we sit here in cases on Law and Crime and we say, oh, gee, we can't figure out exactly what went on because there are no eyewitnesses. Or we've got an eyewitness, but we don't have any forensics to really back up the eyewitness. Do we believe the eyewitness? Well, in this case, you're hitting all of the major bases on this thing. It sounds like a home run.
So here's the deal. What you just gave is a great summation for the prosecutor.
Well, certainly, yes. But look, I mean, I'm also looking at it dispassionately here. And when there are cases here that smell funny, we talk about what smells funny. But
here's my point. That is what the prosecution's job is, to say to the jury, ladies and gentlemen, this is why the narrative and the story that I am telling you at opening and now at summation makes sense and it's corroborated by the evidence. But the defense has a very different job. And the defense job is to try to convince the jury to look at things not in the totality of the circumstances together, but at each thing separately. And they hope, this is always the hope of the defense, and this, by the way, is a very strong case for the prosecution. You're right. But the defense is not going to kick up their feet and say, we're done. And so what their defense is going to be is, ladies and gentlemen of the jury, the prosecution wants you to look at this all together. Don't do that. Don't fall for that. Any one of these next things that I'm going to tell you are reasonable doubt. Here's the inconsistencies that the female victim testified to. A, B, C, D, E, F, G. Ladies and gentlemen, I submit that's reasonable doubt. Maybe it's not. Maybe it is. Next, ladies and gentlemen, here's why the forensics aren't as foolproof as the prosecution says. A, B, C, D, E, F, G. Again, ladies and gentlemen, the judge is going to tell you that you, and only you, ladies and gentlemen of the jury, get to decide what reasonable doubt is. Third, in terms of the interrogation, ladies and gentlemen, you can't listen to an interrogation and you can't even use it against my client until you find it was voluntary. I submit it wasn't voluntary because A, B, C, D, E, F, G. That's what the judge is going to tell you. But even if you do find it's voluntary, here's why it doesn't actually prove the people's case. A, B, C, D, E, F, G. And what I submit to you is you're right. This is a very good case for the prosecution, but the defense is still going to make those arguments. And what they're going to try to convince the jury to do is look at each piece of evidence separately and then say, aha, that one missing piece is reasonable doubt. In truth, it's not always successful. But that's what you want the jury to do.
This interrogation recording, folks, is still playing in court. It's really tough for us to hear. This might be a squad car interrogation. Remember, you've got ambient noise, you've got microphones that are nowhere near as perfect as a studio microphone like what we use here. So it's scratchy, it's being played in court, then it's being picked up by the microphone on the camera, so then it's transmitting through all this air in the courtroom with all this other ambient noise getting mixed into it. It's not a great recording. I wish we could hear it. I heard one line come out of it earlier, quote, I don't even know her name. I don't know to whom the defendant was referring. Could it have been a victim? Could it have been somebody else? Not quite sure, but it's just one of those lines that stuck out in me, at me, rather. So we're going to dip back into this and see if we can pick up a little bit more. Again, sometimes in open court, these things are just a little bit difficult to hear on television. End of direct examination of that officer who was the first one to record an interview with the defendant We just heard him say he didn't know all the details of what had gone on at the time that interview was conducted. And Brian, interesting point here, no cross-examination of the witness. Did that strike you as strange?
Incredibly strange. There are times when you don't cross-examine a witness when you're not questioning the circumstances around it. In this case, I would have gone into the very things we just talked about. You know, where did this interview take place? It took place in your squad car. How did he come to be in the squad car? At that point, was he under arrest? All those things. And you wouldn't ask him open-ended like that. You'd ask pointed question. Isn't it true he was in your squad car? Isn't it true he was in handcuffs? Isn't it true that he was being taken to the station house at this point? I mean, the defense has a strategy. I'm not sure what it is, but I'm sure it's a strategy that is well thought out.
It's probably a long game here. They didn't even give an opening statement at the beginning of the case. Okay, some states, defense teams are allowed to withhold an opening statement until after the state's case in chief. Is it possible here that they're just sort of rolling over and assuming this is going to be a conviction? They don't want to be too combative because if they are, it runs the risk of a possible death sentence later on down the line here, well, if we get to a penalty phase.
Yeah, I don't think that's necessarily it. I do think, listen, they waived their opening. Oftentimes, and it's not done very often, but when it is done, you do that because you want to see how the prosecution case is going to go into evidence.
Yeah, I want to wrap up. We've got another witness, another officer taking the stand. This might be the detective that picked things up once the defendant was in the interview room at the police station. So let's go back live. We are just beginning a 10-minute break in the Shawn Grate case. Brian Wagner, local criminal defense attorney, is here with me on the Law and Crime Network to break down some of what we've just heard. We're also going to get back to some of the horrific testimony from earlier from the surviving victim who was tied up, raped, attacked. She was able to escape. She was on the witness stand earlier today. So, Brian, here we have another police officer saying, look, this guy went back into the apartment of one of the other victims and was touching these various articles that they're now putting into evidence. Why is he going back to the apartment of the person that he had killed?
So the prosecutor will argue consciousness of guilt. This shows that he is guilty and he knows he's guilty and he's going back to the scene of the crime. I imagine they'll try to explain that this is the perversion of someone that commits these sort of crimes. The defense will argue the exact opposite, that, no, this is a good indication of why he's not the actual killer, but he's just a convenient person to level it on.
Well, a couple different sides of the argument. One seems logical to me, the other one doesn't. I know that you have a job to do and that you articulate it coolly and calmly, I might add. But look, we're going to dial back a little bit earlier into the day today because that horrible, difficult to listen to at times testimony from the surviving victim occurred earlier today. They actually delayed lunch so that they could give her a full amount of time on the stand without delaying ultimately the inevitable a lot longer than it could have been. So they did take a break in the midst of it, but ultimately that surviving victim was on the stand for a rather uninterrupted stretch. That's the word. And it was just so hard to listen to. You could listen to the pain. There were a lot of people in tears, the victim. People listening were commenting just how horrible it was. But she got up on the stand and said, this is the guy who raped me. This is the guy who tied me up. This is the guy who abducted me. I was able to get free. Let's listen to some of that testimony one more time.